this is a look at applications, the main types of applications, high-level processes to do with applications, the appeals process. So this second and third dot point go back to the information in the manual for this unit that the registrar of the tribunal put together. Some more information about what goes into an application, and some, I guess, streetwise hints about engagement with regulators that might sit outside the formal advice that you might get on, for example, the Commission webpage or Council web pages, but what it's like in practice. So here are some of the main application types. There's primary permits, and then there's planning permits that fall under some other type of permit. So EPBC is the Commonwealth legislation, Environment Protection Biodiversity Conservation Act, and there are triggers under that act that will mean you need a permit. Depending on the state Commonwealth arrangement, the Commonwealth may flick it back to the state and all of the permit application is all done through the state. But if you trigger one of those EPB listed matters, Commonwealth land, threatened species, Ramsar sites, the internationally recognised wetland sites, then you're going to need a permit, and you're going to need to go through this process at the Commonwealth level. Projects of state significance we've talked about, so I won't labour the point here. This is one of the options for a big project, remembering that there's a number of criteria under the Act that will trigger a POS, and these can be economic impacts. So a project like Lauderdale Quay came in under not many criteria, but the main one was a really significant economic impact. I guess the thing to emphasise about projects of state significance is that they do tend to be a bit of a nightmare for proponents. So you're going to want to know that it's worth your while going down that avenue and having the minister as a decision maker, because, man, the paperwork involved in a POS is amazing. Pause, again, this is repeating earlier material, so I won't labour the point here except to say that there's a lot of lovely legislation relating to projects of regional significance that have never been used because it's just too much of a hoo-ha, and it's much easier, instead of going down the regional significance project approvals path, to just apply for a permit in different council areas. Anyone who's done environmental impact assessment, KGO 381, will be very familiar with this next dot point, level 2 activity at IMCA. So if an activity is listed under Schedule 2 of IMCA, then you need a permit through the EPA. So IMCA lists a number of potentially damaging activities that might be to do with noxious output, so liquid waste or air waste, might be to do with blasting, moving a certain volume of soil. So anything of that kind of high potential significant impact also needs that permit. The planning scheme amendment, that will probably be used less under the new state planning laws. So a planning scheme amendment is something that council cooperates with you on and goes to the commission, and commission hear all the evidence and there's no appeal. So everyone has an opportunity to tell the commission what they think about the planning scheme amendment proposal, and the commission will make a decision. But you wouldn't go to the commission without council writing a report to the commission arguing for the planning scheme amendment. So council have an important approving role in the background there. There's also a concept around urgent amendments that don't need to be advertised. This is different. than the kind of normal planning scheme amendment that you might have come across, where the Commission realises there's a problem. It might be that Council have said there's a bit of a loophole here, you need to fix it. So generally the Council will advise the Commission that there's a little bit of a problem and the Tasmanian Planning Commission will act on it. So the Commission is a bit different to the Tribunal because they're not adversarial, and so they're encouraging councils and all the various stakeholders to work together to have a nice discussion about change with public hearings if necessary, to come up with the best planning outcome, which is what everybody's after, even if individual cases might not go your way. Okay, so there are a bunch of other secondary permits as well, and I'll move to a separate slide for those. There are other processes that need to be gone through to get permits that are secondary to the main planning permit. So you might remember that dam works are different. The actual works associated with the dam come under a different act, water management. You might need a permit under LUPA to get a road to this works, but the actual dam works itself is a different permit. Similarly, anything around threatened species will require a different permit if they're in that part of the development. Forest practices are different, so you might need a forest practices plan by an authorised forest practices officer. You might need a permit to destroy Aboriginal relics. So this is not often a permit to actually destroy, but to conceal. So the relics are often uncovered, so midden, and then you need a permit to further adapt the site, and that would usually mean covering it back up again. Heritage works permit that you might get as part of your development application. Public Works Authority permit, and this can be for even quite modest developments such as driveways that need to go over council land because it's not your land. You might need a public works permit. Similarly, if you're doing a development that involves state roads, you need to talk to the Department of State Growth who manage state roads. So you can see that depending on the type and the size of the application, there could be all sorts of things that you need to tick off in terms of getting final permission. The Midlands Water Scheme is an interesting example. Okay, I realise some of the text on the right here might be quite small, but hopefully you can read it okay. And this is in detail explained in Jared's manual around time periods and why in Tasmania it can be a real problem if councils don't stick to the time period, because the proponent can say that there's been a failure to resolve and then there's trouble. So this is the rough application process. Hopefully you're reasonably familiar with this now, the whole idea of a valid application starting the process off. So if you haven't paid your fees or you don't have all the right information to actually start the clock ticking, then nothing happens. So this is where you might need to talk to the planner who will handle your case and make sure that you've got enough information to actually start the clock on the valid application. So under legislation, council have 21 working days of when the clock actually starts, so not the day of application, but day one is the next day. And if they do need more information, they stop the clock and they wait for the proponent to get back to them. On the left there, if it's a permitted application, there's nothing tricky about it. They've got 28 days to say under section 58 of LUPA what the outcome is going to be. Otherwise, if it involves public advertising and is a discretionary application, then there's these different sets of time that are involved. So if you want to look into some of the detail of this, the sections of Jared's manual on timelines are really good. And you can see notification of a decision. You can appeal within 14 days from receiving the letter from council with a decision. And then if you do appeal, there's 90-day time limit on that, so that the tribunal are pretty quick normally to get back to you. So, and that's a really important part of this whole process. I'm not going to talk about MCA a lot. If you are interested in the environmental side of land use planning, then I recommend that you do the unit that runs over winter, KGA 381 environmental impact assessment that I teach. So this is a real bread and butter of environmental impact assessment, and the Environmental Management Pollution Control Act is our main legislation. So while we don't really talk about MCA in this unit, it is the focus of EIA. And so just briefly, it's important that you know that there's these 3 different levels of assessment under MCA. Level 1 is the lowest level, and so the bulk of permit applications will fall into level 1. The only slightly tricky thing about level 1 is that in situations where perhaps it's particularly controversial, or it's quite a large level 1 development that's getting close to being a level 2, the minister can say, look, I know that it doesn't actually formally trigger Schedule 2 of MCA and all the list of activities, but we want to have a look at it anyway. So that's possible under Section 24 of MCA. Level 2 activities are listed with their trigger levels, so quarries of a certain size, noxious industries of certain emissions will require a level 2 assessment. So it's very similar to the process that you're already familiar with, except that the EPA gets involved because it's a matter of environmental protection. So this is where council, who are the main permit authority, need to work with the EPA to make sure that they're clear on who's doing what. A really useful thing to do under MCA is to submit a notice of intent, and that allows communication of what's required before the permit application goes in. So you submit a notice of intent, because level 2 activities are quite substantial, and so then the EPA can get back to you and say, great, here's what you need to have a relatively smooth process through the approvals. And the other important part of MCA that's starting to get a little bit outside this unit, so you won't really need to come back to it, is that there are different levels within level 2. Of course there are. So 2A, 2B, 2C, again, different triggers on what falls into these different categories, with level 2A being more modest than 2C and 2B being in the middle. And level 3 is projects of state significance. So you're already familiar with POS, and they fall under MCA, but there's a whole different process around that. But still, EPA get involved and will charge for time for consultants in some situations. So I think maybe the last point to make here is that in the separation of issues between the EPA and council, council can't override a condition by the authority. So they're the experts on environmental issues as they fall under MCA, and so when EPA communicate with council and say we want this as a condition, council can't say no. So which could be tricky when there's politics involved. Appeals we'll get into towards the end of semester, and we'll go to visit the Resource Management Planning Appeals Tribunal, and Jared Bryan is the registrar of that tribunal, so he's basically responsible for the ongoing management and operation of the tribunal. Jared is fantastic, incredibly organised and professional, and incredibly good at his job. So looking forward to that. Under the appeals, there's timeframes for appeals. There are practice directions that they're really well written because they are, I was going to say they're aimed at professionals, but there are practice directions in there for lay people as to what to expect when you come to tribunal, because tribunal's not expensive to go to, and so you might not have any legal experience, even really any previous planning experience when you go to appeal. So that soft landing in terms of instructions and the environment is pretty important. The first thing that happens at tribunal is a preliminary hearing, also called a directions hearing, where the tribunal and the case officer who's working on that particular appeal hears from anybody who wants to have a say and sets out what the main matter of interest is, who needs to be involved, and kind of schedules the whole thing. This is the opportunity that people get to have mediation, and so a lot of the matters that appear before the tribunal don't actually get to a full hearing where there's 3 commissioners listening to evidence and listening to lawyers argue the case for their various parties. As part of that preliminary directions hearing, parties can join if they can demonstrate an interest. So even if you haven't put in a formal representation to a permit application, then you can still join at this point if you can demonstrate an interest. So this is about standing, and you should know about standing because we've already covered it in the take-home test. Permits. So you can appeal in various cases if things have not substantially commenced or permits have somehow expired. So the case study that always springs to mind here is that Guns, having got all of their permits, really struggled with the whole substantial commencement that kept their permit applications alive. So that came up in the media when the permit applications were up for renewal, had they done enough work on site to be considered that they'd substantially commenced. And so if you're opposing a particular development, this is something where you might get involved and appeal that actually the project hadn't been substantially commenced. And this happens on a smaller scale too, where you might have a permit application for a house and a shed, and within 2 years of issue of your permit application, all you do is pour a small concrete slab for your shed. That's been successfully argued that the project wasn't substantially commenced and the permit was then expired. We'll talk about this a bit later. This is something that Jared goes into in some detail, so I'm not going to labour it here because I really do think it is worth reading the manual, because the primary reason for him writing the manual is really seeing the errors that are made by consultants, by counsel, that end up being problems in appeal. So he goes through some of these common errors about not adequately describing the process, not actually properly describing the property address so that people can rightly claim that they haven't heard about the application, not placing enough signs around, perhaps development having lots of frontages, more than one frontage, and not all frontages having signs. Getting your time wrong, either underestimating or overestimating how much time was needed, and somebody taking issue with that. You can see them here, and Jared goes through them in detail. This is something that's also very well treated in Jared's manual. How detailed should an application be? And he has a couple of paragraphs in there about applications not needing to be perfect, but they need to be sufficiently detailed to adequately explain what's being proposed and address all likely impacts. And it needs to pass the kind of reasonable lay person test that somebody who isn't familiar with planning, who's not a professional planner, needs to have enough information and needs to be written in such a way that they could understand. So applications might be really quite simple. In fact, it's surprising when you have a look around iPlan what is being submitted, handwritten documents, but if the information is there, there's no need to put people through a lot of time and effort when it's transparent what's being asked for in terms of a permit application. For a big project like the one that we described on the Midlands Water Scheme, a complex application like that might involve some kind of public document, some sort of summary brochure. There'd be the main report, and the technical studies could be very lengthy indeed. So a natural areas report, or natural values report rather, engineering reports could be quite substantial. But again, this is just dictated by the actual application. Obviously, complex applications need that depth in terms of trying to assess the potential downsides of the project and whether us as the public are happy to take on those potential downsides. So generally, planners are looking to try to put in enough detail that the process doesn't get caught up in stopping the timing, so that our requests for further information. So this really can very much stretch out the time that it takes to get a development application through, and that is not something that council should have to account for. But generally, the Property Council timing around how long applications take does include the time that the proponent themselves, the person putting in the application, takes, and that's not council's fault. Yeah, so it's about considering who the audience is, how you might want to communicate with them, how to best present information. So this is more than just being technically correct, but keeping in mind that you're communicating with people. So here's something to be aware of, I guess, that you are communicating with people, and it is important to have a good, positive working relationship, that the regulator learns to trust you. If, for example, you're a consultant surveyor, that you know who you're going to be dealing with in various councils, and that you have a relationship where you're able to provide the right information up front, or if it's not there, you say, look, it's coming, and they're able to call you up and say, I've not got the easement schedule here, no worries, I'll send it over this afternoon. That goes a long way. Council planners are under a lot of pressure, and so being able to make it easy for them is something that's smart practice. The second dot point here, understand the questions that you need to ask and who needs to answer them. The person that you might get when you call the council line might not be the person you need to speak to. So you might be asking for the person who's actually going to be assessing your development application, or a more senior planner that can deal with complex needs, and that might not be the person on the end of the phone. So sometimes you just need to deal with being given the runaround in terms of who you get. But if you don't get the right person at the outset, you might be explaining yourself 3 and 4 times before you do get what you want. So Dan's recommendation for large projects is to have an initial meeting, introduce yourself, introduce the ideas, get any initial feedback, so that when you do put in the permit application, that there'll be fewer stumbling blocks. And if it is a big project, then a second meeting to brief them on the outcomes of the application might be a good idea, to make sure that you do have sufficient documentation and you're not going to get caught up in requests for further information and delays. And know that council officers are often under a lot of stress in terms of meeting statutory deadlines that council have to adhere to, or they can be open to appeal. And finally, to engage with service authorities like TasWater early and understand what permit applications might be needed through them as well. So as part of the normal council development application, sometimes there might need to be a referral to TasWater. Not necessarily a big deal, but knowing that up front, having those conversations up front can save everybody a whole lot of time. So we've been through the main types of application, some of those high-level processes that might involve talking to the EPA. We've talked about appeals, and this is something that we come back towards the end of semester. Jared's manual is fantastic in terms of going through common errors that are made both by the person applying for the development application and also the person assessing it. Some sense of what is required in terms of detail, and obviously this is going to be dictated by the context and the actual type of application, the size of application. And remembering finally that regulators are people, often have a very heavy workload, they're under time pressures. So being really clear and opening up that conversation with them early can be fantastic for all involved.